We get the question very often when a tenant continues to pay rent but never does so on time. And a lot of people would typically look at this and ask, well, is this really the biggest problem that you have? Bearing in mind that the tenant is actually paying, it might not be as grave a situation as you think it is. Unfortunately, what we don't always think about is the fact that landlords, more often than not, have some form of debit order that goes off their accounts in order to cover mortgage bonds. They've got liabilities towards the municipalities to pay rates, taxes, water, electricity, levies to body corporates and the like. And so the landlords do have these obligations. So I think tenants need to be sensitive to this and need to realize that paying on time will ultimately impact them, because if the landlord stops paying the municipality and, for example, the power gets disconnected because the rates weren't paid, then it does impact the tenant. So that's just something to consider as a public notice, as it were. Tenants need to be mindful that they're paying the landlord, but for a very specific reason, and often it's not simply just for profit. So serial defaulters, which is how we refer to them, are any sort of debtor, in fact. But when it comes to lease agreements, it's a tenant who continuously thinks, and this is also another myth that we find happens very often, is this: there's a 7-day grace period. There is no 7-day grace period. There were contracts in the past that did mention that a person would have within 7 days of a fixed date in order to pay the rent. But the reality is the contract says pay it on the first, pay it on the first. So if you fail to pay it on the first, you are in breach of the agreement, and the agreement may be cancelled. But this is where we have to qualify this answer across the board. If the Consumer Protection Act applies, you have to deal with it very differently. And I think Nick will touch on that. Nick will also touch on that when he gets his bite of the cherry when it comes to this question. If the CPA doesn't apply, different circumstances. For example, our firm tries to rely on the argument of repudiation. Now, what is a repudiation? It is, in theory, a breach of an agreement and is dealt with the same. But the difference between a repudiation and normal breach is a repudiation is an understanding that the person that has an obligation in terms of a lease agreement no longer wants to be bound by the agreement in terms of which they have an obligation. And this arises very often when people want to abandon contracts, or they simply have no intention to be held liable. So trying to give them notice that they need to remedy any form of breach is meaningless, because there's no intention at all to perform in terms of those contracts. And through a repudiation, a landlord may be entitled to accept the repudiation. That's in terms of legal terminology, one accepts the repudiation and releases the tenant or the contracting party from the agreement. But with this comes the consequences, obviously, of there being damages that arise or whatever the case is. And the tenant, on the other hand, would have to return the property because now the lease has been cancelled. Now, we don't see this argument very often, because the CPA is so strict on the time frames and the 20 business days notice, and the fact that it seems like a meaningless fight to have if the person is at least still paying the rent, is just paying it a couple of days late. So to have this fight and to go to court and ask the court for determination on whether this position in law is acceptable has been increasingly difficult, because you cannot find the perfect cases in order to do this. But it is definitely an approach. And at the end of the day, also, as a landlord, you want to try make this a threat, or make this a scare where the tenant understands the consequences of actually paying late. So sending out a notice like this, sending out a letter threatening that this is what you're going to do if they fail to remedy the lease agreement, might render the results that you're looking for. So now, Nick, from your side, maybe I don't know if you want to have a discussion of the CPA versus non-CPA lease agreements and how to deal with serial defaulters in those instances.
Yeah. So the method that you use with